Hey everybody, what's up? How's everybody doing today? I hope everyone is well and the family is well and everything's good. So, thank you for coming to Sandra's Stenography, Shorthand, and Court Reporting Dictation. Sandra's Steno for short. And I appreciate all of your viewing and watching and subscribing and hitting the bell for notifications so that you know when I do the live videos. And commenting, which you can leave me a comment below the video, and rating the videos. Thumbs up, thumbs down, does not matter, as long as you are engaged. Now, let's see what we're doing today. I think we're doing, let me pull up this dictation. Today we are doing selection number 29, 738 words on the subject of negligence. We've done this at 100. We are moving on to 120. I'm coming back to the 80s and 90s later. So this will be at 120 words per minute. Today I have on my beautiful dress, which is a halter dress. And because it's very warm here in sunny South Florida, yes, you can wear shorts and t-shirts here. It's just that warm. So I put on a little halter dress today and thought I would be nice and cool and comfortable, which I am. So I know you don't want to hear any more about that. Let's go ahead and get into this dictation, what you came here for at 120 words per minute in 5, 4, 3, 2, 1. Let's write. One of the questions you have to decide in this case is whether or not the defendant exercised that degree of care that is to be expected from a person of ordinary prudence under the same or similar circumstances. The proprietor of a store or similar place of business owes it to his customers to keep the premises reasonably safe. I think the evidence shows that the defendant exercised ordinary care in the lighting of the stairway and basement, that both were well lighted when the plaintiff descended the stairs, and that the steps were clearly visible to any person of ordinary eyesight descending the stairway and the 2 steps from the platform. The plaintiff reached the platform at the foot of the first flight of stairs in safety. There were 2 steps left before reaching the floor. Ordinarily, a flight of 2 steps does not require a handrail, but the plaintiff claims she thought she had reached the floor and fell as she stepped off the platform. There is no claim of any defect in this stairway, unless it be the lack of a handrail. The lights were on and the remaining steps were well lighted. Negligence is the gist of this action, and the burden of proving negligence on defendant's part rests upon the plaintiff to prove by the preponderance of the evidence that the defendant was negligent in the manner claimed by the plaintiff, and that such negligence was the proximate cause of the accident and the injuries sustained. By proximate cause is meant the direct or immediate cause of the accident. The plaintiff, like the defendant, was required to exercise ordinary care under these circumstances, and if the plaintiff herself was guilty of negligence, which was a substantial factor or material element in causing the accident, then the plaintiff cannot recover in this case. The burden of proof rests upon the defendant to prove by the preponderance of the evidence that the plaintiff was negligent and that her negligence caused or contributed to cause the accident. If the defendant was negligent, then his negligence consisted of failing to warn the plaintiff of the remaining 2 steps after reaching the platform, or in failing to have a continuous handrail so as to include the 2 lower steps. But no one has the right to proceed blindly, unmindful of his or her surroundings. Each of us must exercise ordinary care for our own safety. It is for you to say whether or not the defendant was negligent in not warning the plaintiff of the 2 remaining steps, or in failing to extend the handrail to the floor. You have the right to consider plaintiff's age and physical condition in passing upon that question. Did the clerk who went down the stairs with her know of any infirmity on her part? You will also consider whether the plaintiff herself was negligent and whether her negligence caused or substantially contributed to cause the accident. It is for you to say which one of them was negligent or whether both of them were negligent. If you find under the rules given you that the accident was caused by the sole negligence of the defendant or his agent, then your verdict will be for the plaintiff for the full amount of the damages sustained by her. If you find under the rules given you that the accident was caused by the combined negligence of the plaintiff herself and the defendant or his agent or servant, and that the negligence of each was a substantial factor or a material element in causing the accident, or if you find that the accident was caused by the sole negligence of the plaintiff and that the defendant was not negligent, or that his negligence was not a substantial factor or a material element in causing the accident, then in either case, you will find a verdict for the defendant, no cause of action. That is to say, the plaintiff can truly recover in this case. The accident was caused by the sole negligence of the defendant or his saleswoman. That's it, folks. Thank you so much for coming. And as always, happy writing.